Hello, my name's Ian Larkins of Radius Law and welcome to our commercial bulletin in association with LexisNexis. The Department for Business, Energy and Industrial Strategy, BEIS, has confirmed they will introduce a new block exemption to replace the existing retained EU law. The block exemption concerns agreements between producers, distributors and retailers. A consultation on the upcoming legislation has been launched and is to run until the 16th of March. In January, new climate reporting regulations were made law and will enter into force on the 6th of April. Large companies with more than 500 employees and a turnover of more than 500 million are in scope, which in the case of parent companies covers the whole group's aggregate turnover. Certain listed companies are also in scope. A broad range of climate-related information will be required to be disclosed. Official guidance on the regulations is awaited. With some minor exceptions, personal data may only be transferred out of the United Kingdom if the recipient country has been declared adequate or if other appropriate safeguards have been put in place. Usually, the only viable safeguard is to use standard contractual clauses, SCCs, that have been approved by the Information Commissioner's Office, the ICO. To resolve issues that arose from Brexit and other data protection concerns, the ICO has announced new tools are immediately available for use for the international transfer of personal data, that they will only come into force on the 21st of March, assuming Parliament does not object. The new tools include the IDTA, a new international data transfer agreement, and a UK addendum, a form of addendum to the European Commission's standard contractual clauses. The new tools can be used now, although you may continue to use the old SCCs until the 21st of September. All such arrangements must be converted to using the new tools by the 21st of March of 2024. The new tools, similar to the recently revised EU data transfer agreements, require any exporters of personal data to first complete a privacy impact assessment. The ICO published a draft risk assessment in 2021, but the final version is not yet available. We have previously reported on the Competition and Markets Authority, the CMA, publishing its Green Claims Code. The ASA has now also published guidance similarly stating that absolute environmental claims must be supported by a high level of substantiation and relative claims, e.g. greener, must be supported by verifiable evidence that proves the stated environmental benefit over the comparable products. The ASA has already ruled against two brands. Firstly, Oatly, for its claim that Oatly generates 73% less CO2 versus milk. The claim could only be substantiated in respect of Oatly Barista Edition compared to whole cow's milk. Secondly, against Innocent for an advert that implied there was a direct association between choosing innocent drinks and taking a positive action to help the environment. The ASA concluded that Innocent's products did not have a net positive environmental impact over their full life cycles, particularly with its use of non-recycled plastic bottles. In a recently published Employment Tribunal decision, Stacey Macken, a female banker at BNP Paribas BNPP, received compensation of £2 million plus after suffering from inherently sexist behaviour and gender pay issues. The tribunal has also taken the unusual step of ordering an equal pay audit that must be undertaken and published by June. If BNPP discover further breaches, they will be required to equalise the pay between their male and female employees, including retroactively aligning the salaries. Now, whilst BNPP had already taken some steps to identify pay inequality and had already rectified discrepancies, the tribunal criticised BNPP for still falling below the statutory guidance on equal pay, particularly that the process did not consider bonus payments. The High Court has issued an injunction stopping Tesco dismissing some of its warehouse operatives and re-engaging them on terms that did not include a premium pay that it previously described as protection for life. Now, whilst an employer is normally entitled to fire and rehire, a court may prevent it in some situations, including when it contravenes a previously agreed commitment to not change the terms. Since Tuesday the 6th of April last year, organisations excluding small companies that engage off-payroll workers, e.g. contractors hired through their own personal service companies, are responsible for determining their employment status and paying income tax and NICs for those who are deemed to be akin to employees. From April this year, it will be important that organisations pay close attention to decisions that they have made concerning such workers, as the grace period that allow organisations to escape liability for innocent mistakes will end. New regulations come into force on the 6th of April that extend the obligation to provide PPE to workers with a more casual employment relationship, e.g. agency workers. Employers are responsible for the maintenance, storage and replacement of any PPE that they provide, which must be given free of charge with sufficient instructions and training. It is worth adding that the Health and Safety Executive has stressed that PPE should be a last resort, with engineering controls and safe systems of working considered first. We had previously reported on the Supreme Court decision of Smith v Pimlico Plumbers that ruled Pimlico had been wrong to classify Mr Smith as a self-employed contractor rather than a worker. Now, following this decision, the Court of Appeal has delivered another blow to Pimlico Plumbers, ruling that Mr Smith is entitled to paid holiday for all of the time that he worked for the firm. The Court of Appeal decision overturned earlier tribunal decisions that had rejected Mr Smith's claim for unpaid holiday because he had taken periods of leave, albeit unpaid, and his claims for non-payment and unauthorised deduction of wages were now out of time. The Court of Appeal noted that whilst annual leave can be lost at the end of each year, the employer must first show that he has specifically and transparently given the worker the opportunity to take paid annual leave, encourage the worker to take paid annual leave, and inform the worker that the right would be lost at the end of the leave year. A tribunal has determined that a care home acted reasonably in dismissing a care home worker who refused to be vaccinated. The care home had referred to the government and public health advice throughout the disciplinary process and had a genuine concern that it would not be able to obtain insurance coverage if its staff were not vaccinated. It's important to note that each case will be considered on its own facts, and a tribunal may not reach the same decision in another case, particularly where the employment does not involve providing care to a particularly vulnerable section of society. Lee Day & Co, a high-profile UK claimant law firm, has recently publicised on its website that it has served a letter before action on Dyson in relation to a forced labour activity at a former third-party manufacturing factory in Malaysia. Whilst Dyson did not own the factory, and it is likely that it was an arm's-length contract, it's understood that at the time of the alleged activity, the factory was producing goods almost exclusively for Dyson. Lee Day's assertion is that certain UK-based Dyson companies assumed a duty of care to the factory workers. This principle was accepted in the Supreme Court in the Vendetta case, in which Zambia-based claimants leveraged a settlement against the UK parent of the Zambian mining subsidiary that had caused severe environmental damage. That's it for this month. Thank you for tuning in. We've included links to all of the documents we referred to today in a written version of this bulletin. But please do not hesitate to reach out to me or any of my colleagues here at Radius Law for more information.